Well, thank you very much for inviting us to this session. It's a bit of an honour, really. So thank you very much. If I don't get a chance to say thank you to Telly, Dorset, and everyone else that's been involved today, it's been a really interesting sort of opportunity for us, and to Ian from Essex Chambers. If you don't know Ian Brownhill, he's barrister from 39 Essex Chambers. He's quite active on Twitter, and he's a lot of people will have worked with him, I'm sure. So I just want to talk about the reason why we're doing this session. I think that there's a couple of things. About a year and a half ago, I worked with a colleague called Claire Webster, who worked for North Yorkshire County Council. She was a dolls service manager, and I worked in dolls as well at that point. And we had a real passion for human rights and MCA and all things sort of rights-based social work. And we decided to put an event on at that point together. It was a bit of a success actually, and in the process of sort of doing that event, we stumbled in Bradford. We sort of thought, actually, we really want to capitalise on this, and I think there's a lot of learning that we can do, and we sort of came across a couple of sort of avenues for this. We started to visit Bradford Talking Media, and we started to sort of create a sort of space so that we could discuss human rights, and the sort of the aim of that was really simple. Really, it was when people know their rights, they're better placed to protect them. So through a number of sessions, we decided actually we could do a lot more with this. So I think that talking about human rights helps us, and it helps us as a profession to sort of to really incorporate that into our day-to-day practice. And I think that's something that we feel really strongly about. You know, when I was a social work student and my placement and earlier in my career, we didn't really talk about human rights so much. But actually, the more that you start to discuss the different articles and how that affects decisions, and it makes a huge difference to practice, actually. And the second point is that good social work is also linked to strong leadership, and that's something that we feel really strongly about as well. And I think that I've benefited from lots of inspirational people that I work alongside every day, that's social workers and managers and leaders, and they create the atmosphere where good social work can thrive. So that session that we did with BTM, the number of sessions we did, we created a video, and it was really, we thought actually we can do more with that. And Matthew and Jade, who are with us today, will talk a little bit more about how that actually played out. And human rights, and I think that this is at the risk of sounding vaguely political at the moment, I think that human rights should be a low bar. I think that's the sort of sentiment that I would come away with, and to present it as this is the high bar for practice. I think that's a bare minimum. I think, you know, we should be aiming for well-being and sort of really sort of strong outcomes for individuals that we work with, and having that really healthy dialogue between people who draw on care and support and people who commission and deliver. I think that helps that conversation along quite a lot, actually. And so the leadership aspect of the sort of the things I want to talk about is really important to me, actually, because I'm sort of in a, I suppose, leadership role. I sort of manage people, we appoint people, and I think having that sort of dialogue and saying, look, actually, I see it as our job to protect social work so that social workers can be the social workers that they want to be, if that makes sense. And I think that holding back a lot of the bureaucracy, the sort of the funding aspect, and allowing social workers to have that extra visit, or to sort of to think more creatively about sort of individuals' support plans. I think that's something that's really important, something that I've experienced as a social worker, and I think that it's our job to sort of to keep that going. And at the risk of getting into trouble, actually sort of making sure that social workers have the time to reflect and the time to sort of spend with individuals and sort of go on that extra visit or take that extra call and not be sort of tied to a desk. I think that's something that we also feel really strongly about. And I think that drives at the heart of what I want to sort of get across, that the Mental Capacity Act is actually fairly straightforward. It's written down. There are 5 principles. There's a test, but you can have your Mental Capacity Act memorized and in your head, but if it's not in your heart, then it's sort of a different outcome can come out of that. And I think that if you recruit the right social workers and allow them to be the social workers that they want to be, if you get those steps right, then the outcomes for individuals will be quite different to if you've just got a sort of a memorized set of principles in your head. And so some of the things that we've done in Bradford seem like it's not statutory duties, but actually, if we want to create an atmosphere where social work thrives, I think having things like a campaign about Human Rights Day, or creating an MCA A to Z list of things to note when you're thinking about mental capacity. I think that sort of really pays for itself in loads of different ways, but importantly, the outcomes for individuals change, because if you don't have this, then it becomes that I think the local authority or the statutory body overtakes and sort of becomes this machine that doesn't really support the outcomes for individuals. Um, so next, I just want to talk a little bit about a few bits of case law quotes that we've come across over the last few years. This one's come up again quite recently. I can't remember where it comes from, but I'll read it because my handwriting is really bad. Paternalism has no place. Protection of autonomy is the magnetic north of the court of protection. Now, I would maybe sort of change that a little bit. I would sort of say, well, protection of autonomy is the magnetic north of the rights-based social worker. And I think that's a really strong sentiment. I have to sort of add that I've only ever really worked in adult services and spent a long time working with adults with learning disabilities. So this comes from a place where we know that a lot of paternalism sort of exists, and people with learning disabilities often don't have the same rights that we should expect of all individuals in society. So I think that's really important, and it sort of tells, to reflect on it, it tells a little bit of a story about actually this is really important to us. The second quote, it's got the sort of reference there. I'll just read it out. It seems to me to be fundamental to the assessment process that he, the individual, is informed of the purpose of the assessment. Now, this just makes me quite upset, angry. You can see it sort of play out in your mind a little bit. If I tell them they might have capacity, and that'll mean something else, an outcome that I don't really want. So before even contemplating an assessment, you need to know what it is you're going to assess in the first place. And we, that's a lot of the social workers that we work with would say, well, that seems really obvious, but actually, I don't think it isn't always that obvious. And you hear stories a lot now and again where the Mental Capacity Act is being used as a tool to get what the practitioner wants, not supporting what the individual wants. And then we should not ask more of people whose capacity is questioned than whose capacity is undoubted. So that's a really important sentiment as well. And I think that's something that we all sort of are at risk of sort of straying over that line. And I think that's something that's really important as well. I think that at its worst, it becomes discriminatory, and it's, at best, it's something that we just need to be really mindful of. And then this one, this is a really important one, and actually in my sort of job at the moment, it's the one that I sort of keep coming back to. There's a space between an unwise decision and one which an individual does not have the mental capacity to take, and it's important to respect that space and to ensure that it is preserved, for it is within that space that the individual's autonomy operates. I think that's really important, and I think that's, for me, um, when social workers come to speak with me, it's because they're really worried about an individual, but they know what the law says, and they know that autonomy is really sacred and important to protect. And I think that it's one of these ones where, you know, I've worked with individuals where I've been really worried, and you've been there, you've sort of had the phone on, and you think, actually, I'll just leave that on for a bit longer because I know that, you know, on the Friday evening there's going to be a phone call, and I want to support this individual. But actually, to quote colleagues, you know, that's where good social work starts, when you don't sort of walk away and say, well, actually, this person has capacity, my job's done, or you just hide behind that wall of principle one. I'm going to hand over to our colleagues. Matthew, are you there?
Hi, yeah.
Great.
Hi, my name's Matt. So I'm a colleague of Jackson Jade, who'll be presenting in a minute, and I'm just going to be sharing a little bit about the work we did as a team with people from Bradford Talking Media. So I've got Tom here with me as well, who's one of our colleagues from Bradford Talking Media. And right at the end, Tom's really kindly agreed to come with one of his colleagues, Donna, and share just a few words about their experience of this project as well. But for now, I'm going to be talking about our experiences of this project and the work we've most recently done with Bradford Talking Media, creating some videos about human rights. And we started off with a discussion. So we started off visiting the Friday group at Bradford Talking Media and talking about, well, what are human rights? Why are they important? And most of that conversation was about asking people, well, what were their experiences of human rights? What were their experiences of times where maybe their human rights weren't respected, where maybe their human rights were infringed on? And what came out of that was really, really interesting, because people, they were talking about their aspirations and their ambitions, and they were all just really ordinary things and should be really obvious things as well. Things like people just want to live the lives they want to live. They want to work, they want to have friends, they want to have relationships, they want to get married, they want to have children. And what we found was there were some really difficult stories of sometimes those very ordinary aspirations being held back, and sometimes being held back and roadblocks being set up by professionals. And there were lots of areas where this massively overlapped with the Human Rights Act. And so off the back of this, Bradford Talking Media colleagues from there produced a video, which you'll be seeing a little bit later, about why human rights are important to us. And then out of this initial piece of work, we worked on 2 more sets of videos showing, well, how do human rights work out in practice, in real life situations? So firstly, Jade and I drew from some of the themes coming out from our discussion and from the video that had already been produced. And we created 4 more videos exploring different aspects of the Human Rights Act from a professional perspective. And that's going into the kind of nuts and bolts of what articles of the Human Rights Act are in play in different situations, and the way social workers should work to uphold people's rights. And soon you'll see just one of those videos that we produced on voting rights. And voting rights is something we're really focusing on a lot in Bradford at the moment. It's so often overlooked for the people we work with, but it's a really fundamental right and a fundamental part of citizenship. But more important than that really is thinking about, well, is this kind of ideal that me and Jade are talking about in these videos? Is that always how care and support is experienced in practice? So I think one of the most important parts of this project, people from Bradford Talking Media produced some videos about their own experiences of times when their rights were and are infringed on and restricted by professionals, including sometimes social workers. And we're going to be showing just some of those videos today. Unfortunately, we don't have time to show all of them, but they're just really powerful examples of, again, what does this look like in practice, and what does this look like in practice when human rights aren't respected, when human rights aren't protected? And so we're now thinking about, well, what next? So there's a little bit more work needed on the videos. So next, we're hoping to get an accessible explainer of key human rights. One of Bradford Talking Media's roles is to create really effective, accessible information for people who use services. And as Jack was saying, that the more people understand their rights, the safer they are, the better they're able to advocate for themselves. And so we're hoping that Bradford Talking Media can produce an accessible explainer of really key human rights, things like Article 5, the right to liberty, Article 8, the right to a private and family life, Article 12, the right to marry and start a family. And then we're hoping to use these videos as a training resource. And as Jack was saying, this is an area where there's probably a lack of training. There probably needs to be more training for professionals and workers. So that can be used with students and social workers. That can be used in care settings and for support workers who play such an important role. It can be used to help families and carers who, again, with the people we work with, can be so central to their lives. But we have some questions as well and some things we're wanting to explore. So what does that training look like? Is it possible for us to work together to deliver joint training, maybe with people from Bradford Talking Media? And what would that look like? How can we make that work really well? Not just for the people we're training, but also for the people we're there to support and work with.
We're just going to show a couple of videos now that quite often on Teams we have difficulty with sound, but I think they've got closed captions as well. So we'll just see how we go with this.
I have a right to education and a right to vote. The right to vote and the right to education are covered by human rights law. The Human Rights Act in Protocol 1, Article 3, it covers our right to vote. And the right to free elections is absolute, which means it cannot be argued with or restricted. Your right to vote is also covered by the United Nations Convention on the Rights of People with Disabilities, Article 29. The right to participate in political public life. This states that all people have the right to vote in elections and to stand for election if they want to.
Of course, and there is ongoing work across Bradford Council, which is encouraging the right to vote. So every year around election time, we run a campaign called Promote the Vote. We work with people with care and support needs, making sure that everybody knows about the right to vote, and that they can have support to vote if they need it. I suppose this campaign, it's not about telling people who to vote for, or even telling people to vote. It's actually just about making sure that everybody knows that they have a right to vote and making sure that people don't have that choice taken away from them.
Absolutely. As a local authority, we want to ensure that people understand their rights to register to vote and to vote if they want to. And if people do have care and support needs, we'll support them to register, and we'll ensure that if they need additional support to cast their vote by post or in person, then that support is there for them too. We have easy read guides on registering to vote, local elections, and how to vote by post or in person. And we've also produced a voting passport, which can be used to take to a polling station to let people know the type of support someone might need to be able to vote. And staff in polling stations have all had training about the types of support that people are entitled to.
And at this stage, it's really, really important that everybody is aware of the recent changes. So this year, voting at the polling station will be a little bit different, as everybody will need to take some form of identification with them. This is to have a photograph on it, like a driving licence or a disabled bus pass. There will be people who don't have this ID, and if you'd like to be able to vote at a polling station, then the Bradford Council social work teams are more than happy and will be supporting people to fill in the forms that's needed for this ID. But if you do want to vote and want to vote by the post, then this identification is not required.
It's my right to help decide who runs things.
It has to be said that the real driving force in the local authority is Elaine James for everything related to voting rights. So I can't watch that video and think actually Elaine James has been a fundamental force, and she's been sort of banging on, and we've been doing this for quite a few years, and it makes a difference. There's statistics that Elaine could sort of give us right now if she was available to say actually, you know, us going out to see individuals and talking about people's fundamental rights as citizens, about voting and about a vast array of other areas, makes a huge impact and outcomes for people in terms of, you know, whether they go on and cast a vote and how that makes them feel as you know, as their contribution to society in the way that everyone else has, you know, takes for granted.
Walked around the forest and fed ducks together. I felt happy. Enjoyed it, bringing them up, and took the children to the doctors and for a checkup, a health checkup. And we walked in that room, and the doctor said, "Aren't those kids in care yet?" And we sat down, and they had the health checkup. And the doctor knew me from the special school. So that's why she said those things. And when I walked out of the doctor's room, I just was upset, you know, because she judged me and said those things. And in the past as well, we've had social workers that just judged me for some learning disability. And they said you have to have a support worker to teach me how to cook and clean. And I already knew how to cook and clean. Yeah, I enjoyed it, looking after them and bringing them up and doing stuff, going to the park and out for walks in the forest.
Donna's here today, isn't she? Matthew. I just want to say thank you. Oh, hi, Jade.
Hey, yeah, Donna's with me with her son Josh.
Oh, brilliant. I just wanted to say thank you for sharing that story. I think it's really powerful, and I think it tells us a story about actually, you know, about trust actually in some senses, and that Donna's prepared to come here and sort of share her story with us when she's had things in the past that have happened to her that are just horrific, and yeah, so thank you. Move on to the next video.
And the process couldn't do it. The meeting learning what's the difference that make a lot of people for that, huh? They're still getting married.
They got engaged, they got together in 2002 and we got married in 2013. My wedding day, it was a good day. It snowed a little bit and then it became sunny after that. The wedding venue was very well. Where did they get married?
The opportunity to hand it back.
The staff thought it would be good together because of Michael's life here.
I knew they thought you would end up being a chair, but you know. Didn't it? They were. The staff had to do the chair, but.
Too long, didn't that?
Yes, it is.
That's it.
I mean, that's it. There are people that do up by that, but they still get married to stop them. And they still get married and they've got time. Watching the video. I've got some people who do not understand.
I think, Jade, you're going to talk a little bit about your experiences.
Hi, good morning. Yes, so as we've just seen there with Sarah and Michael, they got married about 10 years ago. What I'm going to talk about is a recent case that I've worked on. And it's just proving that we do still come across people with learning disabilities who sadly aren't actually being treated as adults that have a right to a relationship. In this particular case, the couple were living in a residential care home and they wished to get married. In practice, we often see that people living in supported living and residential care homes having the rights infringed on. As social workers, we do know this happens. So I think it's just really important that when we're looking to support people to move into these types of settings, that we're having these really honest and transparent conversations with people about the rights being restricted and how they may be infringed on. Just like any other people, people with learning disabilities, they want to be having relationships, they want to be getting married, they just want to be living a good life. Next slide, Jack. So as I mentioned before, the couple were living in a residential care home. They became a couple and fell in love and wished to marry. They were together for over 10 years, but there were lots and lots and lots of barriers for the wedding to actually take place. The global pandemic wasn't actually the biggest one, unfortunately. And I think in this case, what it really, really highlighted for me as well is that as social workers, we're actually really good at assessing and planning support to address people's physical needs, but we're often overlooking love and relationships. And we know that having a relationship is key to our sense of self, yet when we're moving people into supported living in care homes, we know that there's actually limited opportunities to find love. In terms of this couple as well, I think one of the biggest barriers was the lack of staff knowledge. around people's autonomy and human rights, and people's were not being respected and recognised as being adults with rights just the same as everybody else. It was a very paternalistic approach in that particular care home. And unfortunately, this did present an enormous amount of barriers, both institutionally and emotively. The good news, though, is that this case, I was fortunate enough to work with a number of colleagues who truly lived their social work values and the rights-based practice. So the couple actually married last summer. All the social workers were invited. It was a beautiful day. It was really, really lovely. So they managed to get married, but they also rekindled relationships with some family members who they'd not managed to see for a very long time due to the COVID restrictions that were in place in the care home. So it was a beautiful, beautiful outcome. So I'm just going to actually move on next to talk about some of the comments that were made to us as social workers about the couple that wanted to get married. We'll start there. So she can't buy a wedding dress. It's too much expense just for one day. Well, this particular comment was said to a colleague who was working on the case at the time. The lady's money, the lady's choice. Not necessarily because there was an added barrier there but because she had an appointee in place. We won't get into that because we could be here all day. But from day one, the lady knew exactly what she wanted to wear on her wedding day. And I can confirm that on her wedding day, she did wear the exact outfit which she wanted. So that was lovely. They can't share a bedroom. So this was obviously shocking. And at first, we were trying to unpick it. We were trying to understand what people's worries were, what concerns were, because obviously we want to be like thinking about other people's perspectives as well. But this was actually about money, unfortunately. At the end of the day, care homes, they are businesses, private care homes. And the care home just didn't want an empty bedroom. But from our perspective in social care, that was actually never part of the plan. We wanted to ensure that the couple's Article 8 rights were upheld. So they were keeping both of the bedrooms. And to this day, they still have two bedrooms. One is used as a bedroom, and the second bedroom, it's their own private lounge. So there's chairs in there, and a TV and a radio and such. So obviously in a care home, there's not much space for privacy. So we managed to get around that one. I don't agree they should wed. I've seen a couple get married before in a care home and it didn't work out. So this comment was this was from another professional, and it just has no relevance or regard whatsoever to the couple's wishes and rights. It was quite difficult hearing that one. It's all wrong and a stretch too far. I don't want anything to do with this. Well, again, this comment is really, really sad, but it's actually representative of the majority of the staff's attitudes. And unfortunately, this particular comment was overheard by the couple, and it was said by somebody that they'd known a very long time and that they trusted. Just heartbreaking, really. And then she doesn't have capacity. Well, this one was an endless battle. The lady does have a medical condition where some days she's well and other days she's not so well. So of course the lady's capacity, it was assessed on whether she's able to consent to the marriage, and we weren't able to prove that she lacks capacity. She absolutely could consent to the wedding. But with that in mind, knowing that some days she's not particularly well, we use that for booking the wedding as well. So we booked 2 dates. So if on the initial date she weren't very well, we had a fallback date. But we did actually make it on the first date. She was well on that day. But with this comment just coming up time and time again, some of our colleagues from the MCA team at Bradford actually went into the home and delivered some MCA training. But it still just kept coming round. Every hurdle we had, we'd cross it and then we'd go back to this. She doesn't have capacity, and it was just over and over and over again. So yeah, it was. We had a good outcome, and that's the main thing, really. And again, it's just all down to the social workers' values. I'm just going to end this here now, really, with just a few takeaway thoughts. I appreciate that I've gone through this really quite quickly, but I hope that you've been able to recognise how quickly people's human rights can shrink once we move into a care setting. This first takeaway thought, I think, is just really important, and it's something that I've actually thought about myself. So unless we've got concerns about risks and safeguarding, how often are personal relationships seen as a priority when commissioning services or signposting? And I think everybody should just take a minute to reflect on that, really, think about his own practice. So yeah, thank you very much.
Thanks, Jade. And I would also add to that and say it's the mark of really persistent and sort of tenacious social work that has sort of taken us to the point where we couldn't get our point across to the point where they got married, and quite creative actually coming up with this, the 2 dates, and considering, well, if the marriage can't happen, then a blessing or some sort of mark to sort of celebrate, because that would be really supportive of their, you know, expressed views, despite sort of falling short of that sort of point of capacity, if that was the outcome for there. But yeah, extremely well done for everyone that was involved in that. We've just got one more video to show you, and then we'll sort of have a break for questions or any sort of thoughts people have.
Social night, or we have to go early, about 9:30, so we can get home for 10. Because I think that's the hours for it. But they want to stay till when party finishes. I don't know, it isn't fair that. He usually comes round and helps me get ready, and then I go out, get ready, have a party. He hasn't put makeup on, and I just then go out. He helps me pick what I wear, then we set off to a party, have a drink and dance. Then we have to go home about 9:30 to go, because the staff finish about 10 o'clock, and then we have to go to bed. We want to stay till like 11 or half 11. Yeah. Because you can have a drink and have a dance, listen to music, and see friends, and just watch the bands.
It's, all these videos have been really powerful, and we're really grateful to everyone that was involved. And for that last video, it sort of strikes it right at the heart, because I think it's something that we just know happens. I worked in social care prior to qualifying as a social worker, and unfortunately, we did support people to go out to do things that everyone else in society can do, like go drinking and go to events that go in later into the night. There were those sort of barriers about, actually, if you change your mind at the last minute and want to stay a bit longer, then quite often you don't have that opportunity. It needs to be planned. That doesn't feel right. It doesn't feel fair, and it's something that we're trying to tackle. There are loads of people that are with us on that sort of journey. You most notably Stay Up Late, the campaign that is solely about, you know, sort of pushing back on those boundaries that people with disabilities or extra support needs have. So that's something that we feel really passionate about. I just want to touch also, before we pass on, I think we're going to hear a little bit from the people that sort of actually made the videos. Ruth Allen from BASPO said something a few days ago about a culture change being needed with social work employers. And I think that's right. I think that's, you know, I don't have the answers to that, but, you know, there's that sentiment, the famous quote, you know, culture eats strategy for breakfast. And you'll have heard that before. And I couldn't agree more with that. And I think we're trying in Bradford, we're trying to sort of get that culture right to begin with, because we know that that's the answer. As soon as we set those sort of parameters, then the rest will follow the way that we want. The way that we want to. And we're really lucky to work with people like Elaine James, Ian Burgess, Kirsty MacLeod, Fazila Hafaji, Rob Mitchell. You know, these people that really sort of set the tone about, you know, what's expected in a local authority and the way that we want to do social work. You know, the stories that you've heard from Jade and from Matthew, and the work that we've been doing across many different fronts all support that view as well. I'm just going to end the presentation so that we can see people. Jade or Matthew, are we coming to you guys?
So I think Donna and Tom, you were wanting to just share just a few words about your experience of the project. I think Donna's going to be sharing first.
What I really liked about working on human rights is that it gave us a chance to make other people aware of what their rights are. This is very important to us.
Yes, it was. For me as well. For me as well. It was important learning about all the different rights we have. Knowing about all the different articles gives me the confidence that I need so I can speak up for myself and others.
Hello, everyone. Thank you, Social Work England, for having us today. And I just want to say a massive thank you to Bradford as well for that first presentation. I mean, Jack, Jade, Matthew, Donna and Tom, that was a really powerful presentation. It made me feel quite emotional. And I don't really know how we're going to follow this, but we will do our best. So let's just start with some introductions. So my name's Tilly Baden. I'm the Assistant Team Manager for the Mental Capacity Act team at Dorset Council. Today I'm joined by Sue Farmer, who's our Specialist Manager for the Mental Capacity Act team, as well as Steve Crocker, our Principal Social Worker for Adult Services. And we're here to talk to you today about liberty, human rights, and the concept of the Mental Capacity Act and Human Rights Act in practice. So providing that legal framework and that ethical value base that we've learnt about from Bradford this morning. So first off, I'd like to encourage you all to privately reflect on the following two scenarios, just to try and get the human response going and reflective practice wheels going in your mind. So imagine that you're accused of a crime that you didn't commit. This is a false accusation, but you're potentially likely to go to prison. And how would you feel if you were in this scenario? You might be in the wrong place at the wrong time, but think about those feelings: terrified, furious, overwhelmed, all very valid reactions and emotions. Now think about this second scenario then, so that you've been in hospital, you've been poorly, but you're feeling a bit better now. But out of the blue, a nurse and a porter come along and they put you in a wheelchair, they take you off in a private ambulance, and you think you're going home, so you comply, but they pull up outside of a property that's not your home. It seems to be a care home. You don't know why you're there. This isn't your home. You don't know what's going on. And you're taken inside and you're made to stay there. And you feel like a prisoner, but you haven't committed a crime. And I think you might agree with me that this is a fairly plausible, possibly even quite a common scenario that many people who use care and support services may face. So if this was you and you'd be taken somewhere where you didn't want to be, you didn't know why you were there, how would you feel about this? Anxious, confused, angry, perhaps, trapped, frightened, maybe even betrayed. So fortunately, we have the Human Rights Act in the UK, and I make no apologies to say that the Human Rights Act and the Mental Capacity Act are my favourite pieces of legislation, and they're some of the most important laws of our land. So Article 5 protects our right to liberty, and it mandates strict legal safeguards in place if we're at risk of losing our liberty. We also have Article 6, which protects our right to a fair trial, regardless of whether it's a civil matter or a criminal matter. So these human rights won't be new to any of you as social workers, but hopefully this is a useful reminder of the articles contained within the Act. And whilst all of these articles are important, some of you may be more familiar with these than others within health and social care settings. I think social workers often have to explore these ethical dilemmas within practice when two or more of these rights are in opposition with each other and contradict each other. So, for example, if you're working with someone who's experienced domestic violence and they're within their own home, we need to consider the interactions between the person's right not to be subjected to inhumane treatment, Article 3, with their right to a private and family life, Article 8. So another example of when these rights may conflict with each other is when someone attempts to die by suicide, and there's an interaction between their right to life, their Article 2 right, with Article 8, their right to a private family life. And if we're looking at utilising the Mental Health Act, perhaps, then we're to detain someone in hospital for a treatment or a further assessment, then both Article 5, the right to liberty, and Article 6, right to a free trial, come into play. And these are all issues that social workers grapple with every day. So let's have a look then at some of the wording of Article 5. And I want to draw your attention to the phrase procedure prescribed in law. So this is a really important point when we look back to the identification of the Bournemouth gap, which led to the creation of DOLS. So just as a reminder for you, in the Bournemouth case, HL, a young man with a learning disability, was admitted to a psychiatric hospital under common law. So he lacked capacity to consent to an informal admission, so they didn't use the Mental Health Act. But because he wasn't objecting and he was compliant at the time, they just used common law to admit him to the psychiatric hospital, and he didn't have a recourse to appeal this confinement. So the case was eventually taken to the European Court of Human Rights, which ruled that the UK government was at fault and it was acting unlawfully because there wasn't a procedure that was prescribed in law to enable people who fell outside of the scope of the Mental Health Act to appeal their deprivations of liberty. Hence, DOLS was created. And Sue's going to explore that a little bit more in detail later on. Now, we can also recognise that the language used within the Human Rights Act hasn't really aged well. It's quite out of date. We certainly don't go around calling people vagrants or saying people that have unsound mind anymore. But we have to look past this. So the reason why this language is still used in legal terms is because this is the language that was used within the United Nations Declaration of Human Rights that was written all the way back in 1948. Different time, different language was used, and that was acceptable at the time. So to ensure compliance and consistency, this language hasn't been updated even when the Mental Capacity Act was amended back in 2019. So in plain English then, what does this mean? So we have the right to have liberty, and if our liberty is at risk, we have safeguards around that. We should have speedy access to a judge, and if our legal rights are breached, then we're entitled to compensation. So let's have a look then at some of the landmark court cases that show real world application of Article 5. So after the horrors of 9/11, there was immense pressure on the government, not just in the UK, but across the West, to find suspected terrorists and stop them from committing more atrocities, just like the one that we saw at the World Trade Center in 2001. So the UK government started rounding up suspected terrorists, but without charging them and without convicting them. This doesn't fit within our innocent until proven guilty fundamental and constitutional right. So the A and Others case of 2003 ruled that the UK government's handling of suspected terrorists was unlawful. So the police, anti-terrorism units and MI5 had to change their practice. The next case, James v UK, was a really interesting test case. So previously, for some crimes, people used to be sentenced or given an indeterminate prison sentence, but there was a mandatory tariff which detailed the minimum amount of time that they could be in prison for. After this minimum period had passed, then they would be eligible to apply to the parole board for release, but they would need to show evidence that they had been successfully rehabilitated. To do this, they needed to complete a significant amount of coursework with an offender manager to show that they'd gone through that rehabilitation period. But with government cutbacks and staff shortages, this was really hard to achieve because offender managers weren't readily accessible. So people without that coursework weren't going to the parole board because they couldn't show that they had been rehabilitated. Mr. James challenged this and his case went to the European Court of Human Rights. And there was a unanimous ruling that this was an unlawful policy. There must be proper opportunity to show rehabilitation, and he was awarded significant compensation for his rights that were breached. So the third case here on the slides, hopefully this needs no introduction, the Cheshire West case, which will be familiar to everyone that works in adult social care. Lady Hale, as she was at the time, coined the acid test and gave us our working definition of deprivation of liberty, which Sue's going to talk about a bit more detail later on. So the next article then to unpick is Article 6. So this gives you the right to a fair trial, whether you're facing a public issue or a criminal issue. So, i.e. the state is intervening and you want to challenge this. So, for example, within DOLS, we have the Section 21A challenge that gives people the right to appeal their deprivation of liberty when people are objecting to their placement. And this is an absolute right that they get their day in court. So just looking at the burden of proof then, just as a reminder that criminal cases, we're on a burden of proof of beyond all reasonable doubt, which in real terms means about 99% sure that this has happened. But in civil cases, the burden of proof is on the balance of probabilities, which in practice means more likely than not. So you might be 51% sure one way, 49% sure the other way. And don't forget, when you're assessing a person's capacity, then we're working on this balance of probabilities, burden of proof. So the assumption of capacity has to be displaced by the assessor on the balance of probabilities. So I always think of it as a legal scale, and if the scales have just tipped one way, then that's the outcome. But the closer we are to that 50% mark, the more robust we have to be within our evidence gathering, and our scrutiny needs to be really, really tight. So what does then a fair trial actually mean in practice? So it has to be held within a reasonable time frame. This isn't defined within the Human Rights Act. There are certain statutory timescales depending on the type of case, but these are routinely breached due to the immense pressures on the court systems. They've all faced monumental cuts during austerity, just as all public organisations have. So independent decision makers, so these could be judges, magistrates, tribunal panel members. All of these members take a judicial oath to show that they're going to be impartial and fair within their judgments. Now, open to the public. This is a really interesting one within the Court of Protection, because COP is often viewed as quite a secretive court when it shouldn't be. And it shouldn't always be the case that this is viewed in this way. So some cases have to be heard within closed courts if it's in the person's interest for their safety, such as where we heard recently in the Re-A covert medications case from the Court of Protection citation 44. So that was back last year, but when the judge deemed it necessary to restrict attendance at that closed hearing. But that isn't the norm. Most Court of Protection cases can be heard by members of the public. So I'd just like to draw your attention to the work of Celia Kitzinger and the Open Justice Court of Protection blog. If you're on social media, follow the Open Justice Court of Protection blog and Celia Kitzinger. They're doing really, really great work. So the aim of this campaign is to improve the transparency within the Court of Protection, make sure procedures are scrutinised, and dispel some of the myths that surround the Court of Protection. And whether you're a social worker that goes to court all the time, or whether it's completely new to you and you've never been involved in the court protection processes before, go and have a look, go and attend some hearings, see what's going on. It's really, really interesting. I've done it myself. You can use it as part of your CPD. And if you've got any questions about how to log on to these remote hearings, you can also go in person to some of them, but a lot of them now, fortunately, are remote. So no matter where you are in the world, you can go along and see these court protection processes. So some more landmark cases then, which have direct implications of our understanding of Article 6. So in 1975, the Golder case was taken to the European Court of Human Rights. So Mr. Golder, he was serving a prison sentence when he was allegedly accused of assaulting a prison guard whilst he was in prison. These charges were dropped, but Mr. Golder felt that he had experienced an injustice. He wanted to write to a lawyer to get some legal advice about bringing a civil libel case against the prison guard who he alleged had falsely accused him. He was prevented from doing this by prison staff, and even when he complained to the Home Secretary, who's ultimately responsible for our prisons, they said no, he's not allowed to write to his lawyer. Eventually, this managed to be challenged, and it was retrospectively taken to the European Court of Human Rights, who concluded that Mr. Golder's Article 6 rights had been breached when he was denied access to a lawyer. So the Murray case from Northern Ireland in 1996 raised multiple human rights breaches, but the one that we're looking at today is the Article 6 breach. So he was prevented from having access to a lawyer for 48 hours. And during this time, he was interviewed 12 times by police. So evidence from these interviews was then included within his criminal court hearing, and it ultimately led to his conviction. He was sentenced for 8 years for aiding and abetting false imprisonment. So later on, when this case went to appeal, it was ruled that because his Article 6 rights had been breached because he was denied access to a lawyer for that 48-hour period, and we all have that fundamental right. And finally, I think we can all probably agree that legal aid is not fit for purpose. So in 2014, Teresa Goodovician, along with 4 others who were at risk of deportation following some criminal charges, they were prevented from accessing legal aid, and they didn't have the means to fund it themselves. They were said that they had no recourse to public funds. But when this was scrutinised, because there was such a significant risk to her Article 8 rights that she was going to be potentially separated from her daughter if she was deported, actually it was ruled that legal aid in these circumstances must be granted to protect the person's Article 6 right to a fair trial. So who does the Human Rights Act apply to? Well, everyone, everyone here on this call, public authorities or people acting within public authority business. So even if someone's self-funding their care, if they're receiving a service that's regulated by the state, so by things like CQC, then these means that the Human Rights Act applies to us all. And it should be in the forefront of our minds no matter what we do. Whenever we're planning or delivering services, it's really important that we remember the Human Rights Act and ensure that our practice fits within it. So I'm now going to hand you over to Sue, who's going to talk a little bit more about liberty.
Hi. Thank you, Tilly. I'm going to move away a little bit from some of the legal definitions of liberty and actually start thinking about liberty in a more personal context. And I will run through it in a short while. I will go through doles, as Tilly said. I'll go through some of the legal stuff with doles. But first of all, I want to think about liberty and what does it mean to you? And I think that if you have liberty, you take it for granted. And within this country, most of us have our liberty, we take it for granted and we don't even notice it's there until it's challenged in some way. But we've all taken part in a unique social experiment in the last couple of years with the COVID lockdown. It's given us an experience of what it's like to have restrictions imposed on our own liberty. And I would imagine that I know that our experiences would vary greatly depending on our own circumstances. And I imagine also that it was a dynamic experience for all of us. So I'd like you to think and sort of pause and reflect really about what liberty means to you. So the big stuff as well as the small stuff, and just get into that zone of thinking about it. I'm not offering any answers. I think I'm probably just going to pose more questions. And actually, when we're thinking about liberty and what it means to us, then, you know, when we're looking and working with people with care and support needs, let's think about liberty in a much more rich and wider sense for them. Next slide, Tilly. So I started looking at some sort of simple definitions. I've been thinking about liberty quite a lot over the last few weeks. And I quite like these two. So the state of being free from within society from repressive restrictions imposed by authority on one's way of life, behaviour or political views. I quite like that. It's very holistic. But I'm a simple soul and I like things to pare down really simply. So the power or scope to act as one pleases, the individual should enjoy the liberty to pursue their own preferences. So I really like that. That kind of does what it says on the can. In many ways, there's no such thing as complete freedom. Obviously, if we act as we please, we could come to trouble with the law. So we are bound by law. So there's no such thing as complete freedom. But what it does is it introduces the idea of personal preferences, likes, wants, and values. So it speaks to me of a kind of a richness of life. And I think we need to hold on to that and think about it more when we're working with people with care and support needs. So Lady Hell, or now Baroness Hell as she is, during the Cheshire West case, she said that liberty means the state or condition of being free from external constraint, that it's predominantly an objective state. It doesn't depend on one's disposition to exploit freedom, nor is it diminished by one's lack of capacity. So really clearly, she says that it doesn't really matter whether you're going to do anything about it. It's there. It's your absolute right. It doesn't matter whether you lack capacity or not. That absolutely sits there as a right and something to be respected. So coming back to lockdown, sorry, bear with me a second. How did you feel about lockdown? How did you feel? Did you feel safe, looked after, protected, reassured, or confined, fearful, overlooked and paranoid? Those are just a selection of thoughts. I know it's deeply personal and it would vary enormously depending on our personal circumstances. As I say, I think it was probably quite a dynamic process for all of us, and we probably bobbed around lots of feelings. And I doubt if even two people in the same household experienced the same feelings. And we also have to think about people that have got other factors in their lives, such as domestic violence, physical illness, mental illness, isolation, poverty. They would have factored highly in the way that people experience lockdown and magnified those experiences. And one of the other ways that I think about liberty or being deprived of liberty is a feeling of homesickness. And I don't know if any of you have experienced homesickness, but I've got really vivid memories of when I can't even remember, I don't remember being 7 or 8 years old, but I was probably that young, and going away with a camp with school or something and feeling homesick. And it was a physical, guttural feeling that didn't go away. It stuck with me. And actually, you can feel homesick if you're separated from loved ones too. And sadly, for us within the social care setting, it's common practice. When people move into residential care, we split families up and we move people away from loved ones. And I think, you know, just remember how that could feel. So I happened to quantum research. This was done by King's College London. This is about the experience of lockdown. And I would guess there's no surprises that the higher percentage of people said that their mental health was worse because of the pandemic and that their physical health was worse because of the pandemic. But actually, 12% of people said their mental health was better, 15% said that their physical health was better. So it's not completely clear cut. And I was kind of pondering on my social media really, and thinking that, you know, when I looked at social media, I saw people boasting of how they'd got fitter, lost weight, took up running, cycling, embraced home gym routines, learnt to bake cakes, take up crafting, decorate, make over gardens. Now, I have to say, most of that wasn't my experience. I did make the odd loaf of bread, but that was the extent of it. But actually, some people came out of lockdown better. They used it as an experience. So I think, when we start thinking about people that are deprived of their liberty, what can we learn from that? What can we tap into in terms of the people that had the positive experience? How can we make that work for people? So how can we make people feel safe and trust the people around them? People, if they're looked after, that they know they're looked after, they feel appreciated and valued, that people are protected by people that have got their best interests at heart. If you're confined and you get out, can we get people out and about to have distraction and an experience of being outside? If you're fearful, can we give people information and reassurance in a way that they can understand? And if people feel overlooked, then we need to be including them more in decision making at every level. I'm going to credit Lucy Series with this next fact, but did you know that in the social care system in England and Wales, we've got the largest detained population? So we've got more people that are legally detained in the care system than there are in the prison system. That's shocking, isn't it? Really shocking. And actually, it's estimated that over 300,000 people with mental disabilities are in the social care system now in 2023. That's higher than it was during the Victorian asylum era, when actually there were only 1900 in the 1900s. There was only 100,000 people in state detention, which grew to about 150,000 by 1955. So shocking statistics. So that throws us a really big challenge, both morally and ethically and practically. Those are uncomfortable facts for us, I think. So we have to make sure that if we do deprive people of their liberty, we do it with compassion, care, and that their best interests are genuinely at heart. And so James Mumbley's quote really rings true for me, is what is the point of making people safe if we merely make them miserable? So can we keep people safe, but also protect happiness, promote autonomy and rights? Now, I know our experiences of lockdown aren't the same, but we need to tap into those. So how do we get the balance right for vulnerable people? So protecting people's essential, but we have to take people on a journey with us. Can I have the next slide, please, Tilly? I think I've completely got out of sync with my slides here because Tilly's moving them for me. Can we have the next one? Oh, is it? Oh, wow. I'll stop talking now then. No, sorry, I'll carry on. I digress. Sorry. So I'm just thinking about, you know, when we're working with people with care and support needs, we need to take them with us. That co-production, the stuff that we saw Bradford do, which was amazing. We need to do more of that. We shouldn't be doing to people, we should be doing with people, so that people feel included and they are included. And if we are replacing restrictions on people, we do that in a way that is reviewed regularly, it's minimal necessary, and that staff providing care and support to them know what's expected of them. And I just want to touch on a final and probably not a very happy note, if you like, but when we lose sight of the person, when we lose sight of that individual, when people become numbers and commodities on spreadsheets, and sadly that happens because of pressures in systems, that's when people become dehumanized or can become dehumanized. And we've seen some horrific abuses. The Elder Tree Lodge in Staffordshire 2021, Walton Hall in Durham 2019, and Winterbourne View in 2011. They're shameful and shocking incidents of neglect and abuse, safeguarding issues and failures. They're sadly not as rare as we'd like, but I think that's what happens when people lose power and dignity and rights. And we need to really kind of hang on to the rights-based practice and keeping people at the centre. So Baroness Hale's final slide here for me. I won't read it out to you. I'm sure you've had an opportunity to read it, but this is what she said during the Cheshire West ruling. And I don't disagree with anything that she said. I love the Human Rights Act. I work in an MCA and DOLS team, and I see day in, day out the power of the Human Rights Act. However, sometimes it's the smaller issues, smaller bits of practice that can make a huge difference to people's lives. And I'm going to finish with a tiny, tiny story. And it's about a lady that I once worked with who had care and support needs, and she went into a residential care home. Now, this woman, she was physically very, very frail and fragile. She did have capacity. She didn't want to be in the care home, but she recognised that's where she needed to be. But she was miserable. She was unhappy. The one thing that she wanted was to listen to the Archers. Now, I don't know if there's any Archers fans out there, but she just wanted to listen to the Archers every day. But it seemed like an enormous ask. I've got some Archers fans, woohoo. So, but it seemed like an enormous ask, and she didn't get to listen to the Archers every day because the staff were busy. They didn't always have time to just go and pop the radio on for her. But what a difference that made to her on the days that she got the Archers. So I'm going to pass you on to Steve now.
Thanks, Sue. Thanks. I want to talk a little bit about legal literacy and social work values and how we're supported in our practice by our professional standards and frameworks. So when we look at social work practice and the application of any law and statutory intervention, it's important to understand how the values and ethics of our profession can provide protection and safeguards to those who we work with. And nowhere, I believe, is this more evident than in our application of the Mental Capacity Act, and will be even more vital as we move into the ever-impending landscape of liberty protection safeguards. And I want to reflect how social work values help and shape our practice around legal literacy. Now, I love this model, and it's from our esteemed colleagues at Research in Practice. Now, you might have heard of the adage that 2 wrongs don't make a right. Well, for me, this model is 3 rights that hopefully don't create a wrong. In simple terms, it highlights how legal literacy can be viewed in relation to 3 interdependent yet interrelated rights. And you know, just listening to Bradford, I'm hoping that this has some resonance. Firstly, legal literacy is about doing it right, and that's what the law tells you or advises you to do. In essence, following the letter of the law. Secondly, doing the right things. And this is where you see professional values and ethics play a significant role in our practical application of the law. So although the law tells you can do something, it might not be the right thing to do for individuals. It recognises that we are intervening in people's lives and the law is a powerful tool, and that our professional values and ethical considerations must bring the checks and balances so important to our work. And the final right is about rights thinking. And we've heard so much about that today already. This is about upholding the rights of the people we work with, protecting their human rights and the principles of social justice, fairness and equity. So for me, legal literacy is all these, and it's important that we all practice in a way that encompasses all three perspectives. So how does this link with our Social Work England professional standards? Well, I've picked out a few that reflect and complement the three rights perspective and highlight our responsibility in practicing both ethically and in line with our professional values. Standard 1.2 talks about respect and promote the human rights, views, wishes and feelings of the people we work with, balancing rights and risks and enabling access to advice, advocacy, support and services. Standard 1.7 talks about recognising and use responsibly the power and authority we have when working with people, ensuring that my interventions or our interventions are always necessary, the least intrusive, proportionate and in people's best interests. Standard 2.4 talks about practice in ways that demonstrate empathy, perseverance, authority, professional confidence and capability, working with people to enable full participation in discussions and decision making. And finally, Standard 4.4 demonstrate good subject knowledge on key aspects of social work practice and develop knowledge of current issues in society and social policies impacting on social work. Finally, I just want to talk very briefly about our professional capabilities framework overseen by BASWA, which I hope it's familiar to many of you listening today. Enshrined throughout the practice framework are the values that help us do the right things and promote the rights of the individual. And I just wanted to pick out a few key statements that highlight this responsibility. It talks about we work in partnership with people who use our services. As Sue said, this isn't about doing unto, it's about working alongside. We promote human rights and social justice. We develop and maintain our understanding of the value base of our profession through our career, its ethical standards and relevant law. This is an ongoing commitment throughout our professional practice and professional careers. We use transparency and honesty. We demonstrate confident application of ethical reasoning to professional practice, rights and entitlements. We question and challenge others using a legal and human rights framework. And finally, we critically reflect on and manage the influence and impact of our own and others' values. We understand ourselves and how our own values affect the people that we're working with, and we understand their values and how that shapes their lives and how this influences professional practice. And we recognise and manage conflict and conflicting values and ethical dilemmas in practice. So in summary, I just hope that today in Social Work Week, we can make some sort of ongoing commitment here today to let's do the right things, let's do things right, and let's uphold people's rights. I'll hand back to Sue.
Sue, you're on mute. If you could just turn your microphone on for us, thank you.
Thank you so much. I nearly got away with that one. Thank you, Steve. Powerful stuff. As I said earlier, I was just going to whiz through the recognising a deprivation of liberty and some of the legal stuff around it. For those of you who aren't familiar, and I'm sure most of you will really know, But there are the elements of a deprivation of liberty. So somebody's said to be deprived of their liberty if they're physically confined for a not negligible period of time. And that's known as the objective element of deprivation. So physical confinement is defined as being under continuous supervision and control and not being free to leave. So that's the acid test. Now, not negligible period of time is interesting. So we've certainly seen case law where somebody, I don't know if any of you remember the case law, I should have actually got the quote for the case and I didn't, but it was a young chap with autism who had been taken for a visit to a swimming pool with the plan that he was going to start swimming there, and he'd got really excited and he jumped in the swimming pool fully clothed, and he had a great time in the swimming pool, but it upset a few people because he was in the swimming pool fully clothed and he didn't want to get out. They weren't successful in coaxing him out of the swimming pool, and sadly things escalated to the point that the police were called, and the police actually jumped in the swimming pool and physically took him out of the swimming pool. From his point of view, he was probably quite upset about that. As far as he was concerned, he was just having fun, and he was physically removed from the swimming pool. So things escalated, and he got quite upset. And in the end, they had to put him in the back of the police van, and they kept him there for about half an hour until he'd calmed down. That was seen as a deprivation of liberty. So for about half an hour in the back of a police van, that was seen as a deprivation of liberty. So if you're thinking about a not negligible period of time, you can be thinking as short as half an hour. Obviously, for him, that would have been a horrific experience. So that half an hour would have been probably one of the worst half hours of his life. The other element, the subjective element, is that the person lacks capacity to consent to the arrangements. So we have to have a capacity assessment in place that confirms the person lacks capacity. The deprivation must be imputable to the state. Again, that's a really interesting one. Ian might be able to tell us something different, but the way I read it, imputability to the state is really anything, any time that we know about it, it's imputable to us. So if it's funded by social care, funded by health, in a regulated care home or a nursing home, if it's subject to CQC regulation, if there's any safeguarding going on, if we know about it, and we being, adult social care, local authorities, we are the state, and therefore it's imputable to the state. So all of those three elements have to be in place for somebody to be deprived of their liberty. So in terms of the deprivation of liberty, if a person is confined to a hospital or care home, then they need a deprivation of liberty safeguard authorisation. The care home or hospital who's depriving the person of liberty must tell the local authority, who will arrange for a deprivation of liberty assessment to take place. The deprivation of liberty assessment takes place with a best interest assessor, a BIA, and a mental health assessor, who is a doctor, to say that the people meet these 6 requirements. They also have to meet with the person and consult with interesting parties. I've worked in an MCN Doles team for a long time, and I failed at my own test the other day. So the 6 qualifying requirements are, I really wish we were in a room, I could get you to shout them all out, but we're not. So age, they have to be over the age of 18. So Doles only applies to 18-year-olds. There has to be a mental disorder within the meaning of the Mental Health Act. That's what the doctors confirm. The doctors also have to confirm that the person is not otherwise eligible for to be detained under the Mental Health Act. The person has to lack capacity, so we have to have a capacity assessment. There has to be a judgment that it's in their best interests, and also that there is no refusals. So that would be if somebody with a power of attorney or a deputy objected on behalf of the person to that confinement, or if the person themselves had previously written an advance statement to that effect. So that's the 6 tests that have to be taken passed during the deprivation before the Doles can be granted. And as we've talked about today, if the person objects to the care arrangements, under the Human Rights Act, they have that absolute right of appeal against that detention. And under Doles, it's done through the Court of Protection, so the Section 21A challenge. So that safeguard of the person's Article 5 rights. So Doles in the community, Doles authorisations can only be granted in registered care homes and hospitals for people over the age of 18. So that's the dole schemes that we know, the ones that local authorities run up and down the country. But through the Cheshire West ruling, they also made it clear that people could also meet the acid test in other settings. So that could include people in their own home. It could include people in supported accommodation, or other types of perhaps adult fostering, shared lives, those sorts of things. So if people are in those circumstances and they meet the acid test of being deprived of their liberty, then that has to be authorised by the Court of Protection. A local authority or a key worker from the ICB, the Integrated Care Boards, for people that have got continuing healthcare funding, they have to make an application to the court for that deprivation to be authorised. That's sometimes referred to as a community doles. And if there's no objection, there is a streamlined procedure called the re-ex procedure. I would imagine any of you out there that have ever done the re-ex procedure would be screaming at the screens now. It's not particularly streamlined. It's still a very bulky piece of work to do. And there's lots of people that are deprived of their liberty out there that we haven't got around to getting those community doles for. 16 and 17-year-olds, so they don't come under the scheme of deprivation of liberty safeguards, but doles, the Mental Capacity Act applies from 16, as you know. But we've now had case law that's actually clarified the situation around 16 and 17-year-olds. So it bobbed around for a while between the courts to decide whether somebody with parental control could consent to a deprivation of liberty on behalf of a 16 or 17-year-old. But it's really clear now through case law that a 16 and 17-year-old who is deprived of their liberty must have that authorised by the High Court, and it sits outside of the scope of parental responsibility. That's me, I'm done. Right, I'll hand you back to Tilly.
Thank you, Sue. So where next, just as a final reflection then. Now today we had hoped that we'd be able to talk to you a little bit more about LPS or Liberty Protection Safeguards, but we are still waiting for the final code of practice. It's supposed to be coming in winter. We're now officially in spring as of the 20th of March. So watch this space. We don't know. We don't have any information. I'm sure that's probably some of the questions that are coming through. When will LPS come? We don't know. What we do kind of know a little bit more about is the UK Bill of Rights. And this has been a really contentious draft piece of legislation. So the Conservative Party have been headlining this. They've tried to bring it in for several years now. The government want to limit access to the European Court of Human Rights and bring powers back to the UK government. So in doing this, it would allow the government new powers to strip back some of our human rights that we've come to know and love. And these may suit domestic policies, such as deporting foreign nationals, preventing human rights claims that arise from the actions of military personnel overseas, and requiring the courts to give great weight to the views of Parliament when balancing rights-based issues. So a huge change and shift from our Human Rights Act that we know back from 1998. It has been condemned by many high-profile organisations such as the Law Society, Human Rights Watch, and Amnesty International. So things have gone quite quiet in the government about the progress of the bill since the first reading last summer. It is still technically within the second reading phase within the House of Commons, so it's got quite a lot of hurdles still to go. But there's mounting pressure for it to be scrapped. But again, we don't have the answers. Watch this space because social workers may need to be called to action to try and challenge some of these practices that the UK Bill of Rights would want to bring in. So finally, I suppose the key message to take away today from our presentation is that whatever government is in power, whatever's going on locally, nationally, and in the world events, our value base doesn't change. Social workers are in a real powerful and privileged position because we have the knowledge to support people to uphold their rights. We're in positions of power and influence. We balance our obligations between the rights of the the people that we're supporting, our professional autonomy, and the obligation to our employers and the state. And just like human rights, or just like safeguarding, human rights really are everyone's business.
For those of you who don't know me, my name's Ian Brownhill. I'm a barrister at 39 Essex Chambers. Most of my time is spent dealing with adult social care or medical law issues. Often, those are complex court of protection cases, sometimes judicial reviews, quite often using the inherent jurisdiction of the High Court, and sadly, sometimes in respect of inquests. And lots of the cases I do are around sex, relationships, medical treatment for both adults and children. And I was the barrister, the one who was the thorn in some of your side, I'm sure, who took the JB case, all about capacity to engage in sexual relations, from the High Court to the Court of Appeal, and then ultimately to the Supreme Court. And I'll be honest from the outset, despite the complexity of my job, I must confess I am a bit nervous about today. And that's not nervousness about the contents of the presentation or the contents of the law, but in terms of the responsibility which I think is upon lawyers, especially when we enter spaces like this. I'll be honest again, the law is not always accessible. Principles are sometimes oversimplified, and I think that lawyers and professionals who work in health and social care have a responsibility to make sure that people understand their rights, that professionals understand their duties, and together that we think about how power can be used to protect people's rights. And that's what I'm talking about today, the value of protection. And the value of protection sounds like a very grand title for what I'm going to discuss, but in my mind, it's something really very important about what we do when we protect other people within society as part of our professional roles. And that equally applies if you're a social worker, if you're a lawyer, if you're another professional who is working with the groups of people who need to have their rights protected. And one of the starting points that I just want to talk about very briefly today is one of the articles of the European Convention on Human Rights that we haven't really focused upon yet, and that's Article 3. So Article 3 of the Convention says we all get to live a life free from torture and degrading treatment. There's an absolute bar on people living a tortured or inhumane or degraded life within our society. But with that absolute bar, there's also a responsibility and a duty upon the courts, upon public bodies, upon those people who are employed by public bodies, to make sure that when we know that somebody is living in a way which is inhuman or degrading, or that they're subject to torture, that something happens about it. And lots of the European Convention on Human Rights case law that comes out of Strasbourg isn't actually about government bodies going out and torturing people, thank God. In reality, a lot of it is about the duties incumbent on those public bodies when they know about something to go out there and to do something about it. And one of the things that I want to emphasize today when I'm talking about the value of protection is that this isn't just something which has come out of the ether, come out of nowhere. This isn't something that even goes back to 1948. This is something that goes back much further than that. So there's been a concept in the English law since 1606, at least, whereby the common law has recognized that the state has a role in protecting its citizens from harm. So this isn't something new. This is something that we need to think about, and not something that we always do think about on a day-to-day basis. And one of the things also that I want us all to think about is the concept of our own free will and our own free choice. As was already said earlier today, we live in a rules-based society. We can't do what we like. We can't always do with our bodies what we want to do with our bodies. And there's a sort of famous authority, a famous piece of case law that all law students love reading about when they do criminal law, which goes back to the 90s. And in the 90s, the case of the Crown and Brown came before the House of Lords, as it then was. And the House of Lords had to wrestle with a question. And in that question, it was essentially, could a person decide to allow another person to cause them so much harm that it would amount to actual or grievous bodily harm? And the answer of the House of Lords was no. And so in reality, one of the things that happens on a day-to-day basis in my practice is sometimes I'm faced with a situation whereby the professionals with whom I'm working or who I'm against in a case will turn around and say, well, this person is choosing a life whereby they're being degraded or tortured. It's their right to go and choose that. There's nothing that we can do in those circumstances. We're not obliged to do anything that would have a protective value or a protective imperative towards them. And so we just have to let them live their life. And I'm afraid to say that if you're someone who subscribes to that view, although I have absolutely no doubt it's well-intentioned, it doesn't actually fit with the law. So if we accept as a basic starting point that in some circumstances the law requires for a person to be protected, what's the problem? Where do issues arise? And issues really arise with a balancing concept. And the balancing concept between taking on one side all of our right to live a sort of free life unencumbered by the government telling us what to do, without lawyers telling us what to do, without social workers, police officers, doctors, nurses telling us what to do. And then on the other side of that, a need to try and promote somebody being able to live what would probably put colloquially now as their best life. And one of the things that has always been a concern since the Court of Protection in its current form has been around is this idea that some professionals, some public bodies will go out of their way to come to a conclusion in a particular case. That means that the person will be protected at all costs. And Mr. Justice Baker, as he then was, grappled with this early doors with the new Court of Protection. So in the KK and STCC case, Mr. Justice Baker had to think about whereby you had a scenario that professionals may put in place in their work a greater emphasis on someone being safe rather than someone being comfortable or happy. And he described that, looking at other forms of cases, looking at previous cases that are mostly referred to in respect of children. He referred to that as the protection imperative, where people were doing capacity assessments, and the real reason they were doing capacity assessments was to find the person lacking capacity. Because if they found the person lacked capacity, they could then go on and make a decision for them that would make that person safe. And so Mr. Justice Baker, as he then was, turned around and said, well, hang on, we've got to stop this. It's the cardinal rule to make sure that before we start taking decisions on behalf of somebody else, that we've established that that person cannot make the decision. Not that they're making an unwise decision, but that they cannot make the decision for themselves. And so what he was saying to all of us, lawyers, social workers, other capacity assessors alike, was that we really have to be disciplined. Because actually, when we use the protection imperative, when we skew capacity assessments to find that someone lacks capacity so that we can keep them safe, actually, in truth, what we're doing is we're infringing on that person's rights. because we're not protecting them. We're not protecting their rights. We're actually taking their rights away from them by finding them to lack capacity, where in reality, what that person is doing is making an unwise decision about the fundamental way in which they live their life. All of that aside, though, one of the issues that comes up time and time again in the most serious of my cases is, what are we all to do in respect of the concept of protection? How is it that we protect a person's rights? What are the steps that we take, and how do we balance protecting that person's rights against what might be their expressed wishes and feelings? They might say, I don't want this thing to happen. But we might think otherwise, that if that thing doesn't happen to them, there may be a very dire consequence. And really, it's this very strange concept to be missing from adult social care law. And it's really important to remember that a lot of the cases that we're dealing with might be straightforward now, but there'll be that one case that comes along where you're required to think about something which may have a life or death consequence, or it may have a consequence whereby a person can be subject to really extreme forms of inhuman or degrading treatment. And again, one of the things that I want to be really blunt about today is that there are bad people in this world. And those bad people sometimes want to come along and hurt the service users who we are working with. Now, when those bad people come along and they want to hurt the people we're working with, the question then comes, well, how do I balance things? How do I go back to that balancing exercise that I've already alluded to? What do I do about protecting that person? And it's always struck me as a curiosity that the word protection doesn't appear anywhere in the principles of the Mental Capacity Act. In fact, although I'm now rapidly going through it in my head, I don't think it appears in sections 2 and 3 about assessing capacity, or indeed in respect of section 4 about making a best interest decision on behalf of someone. So it's a difficult starting point with the MCA, which is, let's face it, heard by the Court of Protection, that we don't really get direction as to what protection in those circumstances means. So where do we then look next? Well, obviously, the next thing we look at is the statutory source of duties in respect of safeguarding. And for those of you based in England, where you find your statutory definition of safeguarding is that part of the Care Act. And again, when you look at section 42 of the Care Act, all about safeguarding, what it does there is it identifies that there are some people who, because of their care and support needs, are unable to protect themselves. Great. But what it doesn't do, the bit that's missing, is it doesn't then go on to tell you what you should do or what you can do to protect that person. So section 42 almost sits there like this relatively strange gateway that you identify a person who needs help or who needs support in respect of protecting their own rights, keeping themselves away from abuse, but it doesn't really tell you what to do next. And there are other pieces of legislation that deal with specific circumstances. So the Forced Marriage Civil Protection Act changed the Family Law Act in respect of people who are subject to forced marriage. And so the Forced Marriage Civil Protection Act comes along and it says to the court, okay, we're going to give you a new power. And your new power is to use injunctive provisions in order to stop someone being subject to a forced marriage. And that is something that all of us, I hope, innately support and think, do you know what, that must be the right thing to do. It must be the right scenario whereby someone steps in to prevent that another person is subject to a marriage they don't want to enter. But what the Forced Marriage Civil Protection Act did was it also again entered into law a concept of protection, but it didn't tell you how to use it. So the court comes along, the court is empowered to make these particular injunctive orders. But then it says, when the court is making those orders, the court has to balance that. It has to think about the person's expressed wishes and feelings. And so you may find yourself in a case, as I have done more than once, where a person on the face of it is being subject to a forced marriage, but who may seemingly acquiesce to it, or maybe even be keen on it. And then at that stage, the law falls silent. And it doesn't tell you how to go about that balancing exercise, where you've got one set of rights in one hand about keeping someone safe from a forced marriage or free from a forced marriage. On the other hand, someone saying, I want to do something that is contrary to my own welfare. So where do we find balance? The direction of the Court of Protection, and indeed the wider family division, who deals with children, vulnerable adults, and ultimately the Court of Protection, who deals with adults who aren't able to make certain decisions for themselves, has been to recognise that there is a balancing act at the centre of our law. It's not 1606 anymore. So in 1606, something, I can't even remember what the case was about, something to do with James I and someone being taken out of the jurisdiction. It was all very complicated and all very highfalutin. Now, as the laws developed, the law's principal focus before was effectively about avoiding all risks, wrapping a person up in cotton wool. And that didn't matter if they were a child or a vulnerable adult. But as the law has developed, you start to see judgments from people like Sir James Mumby, from people like Lord Justice Baker, from people like Mr. Justice Hayden, who've started to grow and develop the law into a more finely put balancing exercise. And Mr. Justice Mumby, as he then was in X and MM, started to think about the reality of life. So the reality of life, and he quoted an American jurist, is that it's entirely an experiment. There are things that we do, there are risks that we take in all of our lives. And he emphasized that we must avoid the temptation to put physical health and safety above everything else. Now, that part of the quotation is really important, and that part of the quotation sticks in everyone's head. The bit that doesn't stick in everyone's head is what he then goes on to say. He says, sometimes, essentially, you might have to do something. And he starts talking about the balancing act. He says the emphasis must be on a sensible risk appraisal, not striving to avoid all risk, whatever the price, but instead seeking a proper balance and being willing to tolerate manageable or acceptable risks as the price appropriately to be paid in order to achieve some other good, in particular, happiness. So actually, he's not saying we just do whatever the person wants to keep them happy. He's saying that we have to accept there is a degree of risk in life. We have to accept that we can't eliminate all risk. And what that means in reality, like it or not sometimes, is that we do have to take steps sometimes to achieve a better balance for that person in their life if they can't achieve that themselves. So one of the questions that I've asked during my time as a Court of Protection barrister is whether or not the concept of protecting people has simply gone out of fashion. Is it something that as the law has developed, as rights have developed, as the sort of democratic society we live in has developed, is it something that we're no longer willing to tolerate as much? Do we simply say, this is my life, these are the four walls of it, you can't come inside? And in truth, that can't be right, because what we have to recognize are the circumstances when sometimes protection is necessary. And for those of you who know me, who might see me as someone who is always banging the drum about autonomy, always banging the drum about P's rights, you may think it's quite strange that I'm here today talking to you about the value of protection and trying to put it back into your minds. But actually, I think it's really important that when you look at the detail, you'll start to see why protection is important. So the first thing I want to think about is what the research actually says with regard to protecting people. And one of the great things about the Care Act was the birth of Safeguarding Adults Boards, was the birth of Safeguarding Adults Reviews. And between 2017 and 2019, there was a broad review of the themes coming out of SARS. And one of the interesting things that is born out of my own experience, but is reflected in the research, is that there remains an issue in respect of training and understanding. Now, lots of people will have had training about how the Mental Capacity Act works. I appreciate that this particular piece of research was 2019. And one of the things that I'm heartened to say is that the vast majority of cases with which I'm dealing, there is a clear understanding of the principles of the Mental Capacity Act, the concept of capacity, and the concept of making best interest decisions. What there's not always a understanding of is what happens in those scenarios, those high-risk situations where you have to do something proactive to protect a person. And one of the really interesting things from the research was that it zoomed in on particular issues. So safeguarding, self-neglect, mate crime, disability hate crime, intergenerational abuse. Now, the fact that that was zoomed in on really does reflect my own personal experience. So when I was doing the SF case about a young woman with learning disabilities who was being groomed by a grooming gang, in that case, the case went before the Court of Protection. And I was in a really odd situation because I was there representing SF, this young woman who was being systematically abused by a group of men who wanted to sexually abuse her. But I was the one representing her who had to make the arguments for protective measures to be put in place. And in that particular case, it was about the use of injunctions. Now, I absolutely am not critical of the local authority in that case. I'm not critical of the particular social worker involved at all. In fact, I have a great amount of time for that young woman's social worker. She really cared. She was really worried. What I am critical about is that whilst we've reached a situation where people have training and mental capacity, there's then a gap in terms of what do we do? What are our legal options in respect of taking the next step to keep somebody safe from others who would harm them? And again, one of the really interesting things that came out of the research from the Local Government Association was that there still remained a lack of understanding in respect of the inherent jurisdiction of the High Court, the great safety net there to protect people who, but for the external influence of another, could make decisions for themselves. So I don't think it's that protection has necessarily gone out of fashion. I think that there's an understanding there of the basic building blocks. But what there's not necessarily the understanding of, or what there hasn't been necessarily been the training in, is the more offensive putting things in place to stop those people coming into your service user's life and impacting it negatively. And again, a lot of the case law, a lot of the recent case law especially, doesn't necessarily deal with the balance between autonomy and protective endeavours, protective orders. doesn't also necessarily recognise the interrelationship between the two of them. So lots and lots of the case law that comes out of the Court of Protection is actually focused on the medical cases that we do. So if somebody isn't able to consent to having a particular procedure, so an amputation, for example, or the withdrawal of life-sustaining treatment and things like that. And so lots of the case law and lots of the noise out of the Court of Protection, or the zeitgeist out of the Court of Protection, is about autonomy. And that is not a bad thing. That's actually a wonderful thing. And that's something to which we all should subscribe. We have these great sound bites, if you like. In GU, we had autonomy does not evaporate with the loss of capacity. In D, we had the importance of respecting individual autonomy. And then in Lawson, we had this idea of the imposition of a legal framework which is overly protective, risking inhibiting personal development and failing to properly nurture individual potential. So we have all these great sound bites about autonomy and the importance of autonomy. But one of the problems with the Court of Protection and its body of case law is that very much of it is focused on those high-octane, high-end, very dramatic medical decisions. Less of it is focused on those day-to-day balancing exercises which you as social workers have to go about and have to do. Now, that's not your fault. That's probably our fault as lawyers. But it does mean there's a gap there, and it does mean that sometimes people consider protective steps to be the enemy of autonomy. And again, if I can win 1 point with you today, as if I was standing before the Court of Appeal, it would be to convince all of you that protection is not the enemy of autonomy. It is in fact quite the opposite. So let's think for a moment about the inherent jurisdiction, and the inherent jurisdiction being the epitome of a protective jurisdiction. So we have on one hand this idea of autonomous self-determination. I can go out onto the street, do what I like today, as long as it's within the realms of the law. However, if due to a problem with the functioning of my mind or brain, I can't make those decisions for themselves, somebody else will make that decision for me by applying Section 4 of the Mental Capacity Act. But there's a problem. And the problem is the people who have capacity but can't make their own decisions, can't make their own autonomous decisions because of somebody else. So if mental capacity is about an internal issue in respect of functioning, the inherent jurisdiction is about an external factor impacting on that person's ability to make an autonomous decision. So in the SA case, again, Mr. Justice Mumby, as he then was faced with the question, what happens when you have a scenario where a person can't give real and genuine consent, who is deprived of free choice, and who, as a result of that, can't make decisions for themselves? And so what he did in that case was say, do you know what? Let's look back at our legal history, 1606 and beyond, and say there is a great safety net in place for those people, so that essentially the High Court can step in and protect that person if they're under constraint, subject to coercion or control or undue influence, or for some other reason deprived of that capacity or deprived of that autonomy, if you like, to make a particular decision. So there exists within the law this great protective jurisdiction that exists and continues to exist. And the inherent jurisdiction is completely about protecting autonomy. The language, again, in respect to those case law, that case law is out of date. So we're talking about early 2000s. The language within it talks about adults who are vulnerable. And again, I think talking about vulnerable adults is a complete red herring. What we need to talk about and what we need to focus on, and what we've started to focus on today, are those adults who are deprived of their autonomy by the actions of other people, about people who want to come along and who want to deprive that person of the ability to exercise their rights freely. So it's things like predatory marriage, it's things like sexual exploitation, it's things like county lines. And it's about considering in those circumstances, are we actually here talking about things like unwise decisions? Or are we actually talking about someone who can't make decisions because of the actions of a third party? And my argument today to all of you is that those people deserve protection. We have a duty to protect them, and that we should step in, and that capacity is not the only issue that guides us in those cases. But in respect of the Court of Protection, in respect of people who lack capacity to make decisions for themselves, we also have to recognise that there are times when we need to use the Court of Protection to take protective steps on behalf of other people. So I've already mentioned to you the SF case where we went and we got an injunction against someone who was effectively grooming, sexually abusing someone who lacked capacity to make decisions for themselves around their sexual relationships. In the Re-G case that was in the Court of Appeal last year, on that occasion, we were again arguing before the Court of Appeal, and you think the Mental Capacity Act has been in place now for a number of years, so we were having this argument relatively recently. We were arguing about what the court's power was. And again, what the court emphasised in Re-G was that if you make a best interest decision on behalf of somebody, and you're there to protect that best interest decision on behalf of the person who lacks capacity, sometimes it's necessary for the Court of Protection to step in and to make an injunction so that you can stop that best interest decision from being frustrated or undermined. And the reason why you're asking the Court of Protection to step in to make that injunction is to protect that person's situation, to protect that person's interests. So in the Re-G case, it was all about family members and their interrelationship with medical professionals, mainly, who are providing care to a family member. So the court has these tools available to it when they're needed. So if you've made a best interest decision on behalf of somebody so they can go out and live what I described earlier as their best life, sometimes it's necessary to take the extra step to protect that person by the use of an injunction. Ultimately, if somebody comes along and breaches an injunction, that person can be fined and that person can be sent to prison. So there is a lot of strength in protection. It's not an anathema to protecting that person's autonomy. And in fact, I would argue, and I argue to all of you today, that sometimes the only way to protect your service user, your P's autonomy, is to take that extra step and to secure an additional legal protection for them. I don't want to talk lots about the JB case because I feel like I've been talking about it for the last 5 years in various different forums and after the decision was made. One of the things we have to remember about the Mental Capacity Act, and one of the things that's difficult for all of us, is the reality of the situation that the Mental Capacity Act is not just about protecting P and about protecting P's rights. So although our overarching driving focus should always be upon P, Lord Stevens disagreed with our arguments in that regard. He said you can't just look at P's rights. And he said the criminal law is about prosecuting behaviour that's classed as criminal and punishing offenders by the state. So that's straightforward, put that to one side. But he went on to say, in civil proceedings where we're using the Mental Capacity Act, that courts must balance the promotion of the autonomy of vulnerable persons with their protection from harm. Again, what I've been arguing for this morning. But he then went on to say, all while, so far as required by general principles of law and the court's obligations as a public authority under the Human Rights Act, having regard to the rights of others. So you can't treat P like an island, Lord Stevens was saying. He was saying, when you look at these decisions that you're making on behalf of P, using the Mental Capacity Act, you're not there just to uphold P's rights, but sometimes, in some cases, you have to uphold the rights of others too. And that's an incredibly difficult thing for all of us, especially me, to get my head around, because I've always been focused and driven on looking at the rights of P. But Lord Stevens says, and there's no way of going behind it, and I don't go behind it for a second. Lord Stevens says you have to look at the wider ecosystem of law and rights and think about not only the rights of your service user, of your P, but also the rights of others. So if I've convinced you about the value of protection, then I'm hoping that I can turn you all into advocates for the value of protection, that it's something that's worth fighting for. And if I haven't persuaded you it's something worth fighting for, I'm afraid to say you're bound by the Social Worker Code of Ethics. So that says you have to act with informed consent of service users unless required by law to protect that person or another person from the risk of serious harm. So what might that mean? Again, I'll be honest, and I'm speaking here as Ian Brownhill. I'm not speaking as 39 Essex Chambers. I'm certainly not speaking as Social Work England. Sometimes other public bodies will not want to step in and take steps on behalf of a person because that person has a mental health problem, or that person has a learning disability, or that person has a disability. And one of the most frustrating things I have as someone who spends a lot of time in the Court of Protection is trying to persuade other public bodies that they have a duty to P. And in particular, I mean law enforcement bodies, not necessarily always the police, sometimes the police, but other agencies too, who have a law enforcement function. And sometimes I would say that social workers need to be advocates on behalf of their service users and say to the police or say to other law enforcement bodies, simply because this person has an issue with their mental health or their understanding of something, it doesn't mean that they're not entitled to the protection of the criminal law. The other thing that I want to, again, emphasize and embed and hopefully persuade you all of is that sometimes, although it may not seem like a social work function to take an urgent protective step, sometimes, guys, you are the only people in the room, and that happens more often than not. So again, the SF case is a really good example. SF was being systematically sexually abused. The social workers were the only people in the room with me. The social workers couldn't engage the police in that case. And there had to be some responsibility for taking urgent protective steps. It can be the same with financial abuse. You might have been in that situation where you've sent a referral to the public guardian and you've waited a very, very long time for the public guardian to come back and they haven't come back yet. Again, sometimes that means that you will have to take urgent protective steps on behalf of your service user. On other times, it means taking decisions which are purely unpopular. So lots of you may have recently read the DY case that I did about a young man who had a paedophilic interest. And in respect to the DY case and those cases where the Court of Protection deals with people who are offenders, one of the things that sometimes means is that external agencies, police, probation, things like that, sometimes put pressure on you to impose more restrictive regimes than what you think are necessary. You're protecting that person when you turn around to your colleagues in other agencies and say, I can't do that. And when you explain to them that your function is different to their function. And then finally, protection is sometimes creating a space for P to make decisions for themselves or express their wishes and feelings. That can be removing them sometimes from their family home and putting them somewhere else in respite so they can make a decision unencumbered. It can sometimes be applying for an injunction. It can sometimes be the instruction of an advocate or a paid RPR in a dole's case. But again, protecting someone isn't always about imposing a restriction on that person. It's sometimes about imposing restrictions on others so that you can create a space for them so they can say what they want to say about their life and what they want to happen within it.